Hi guys!
Hi guys! Hi guys!
Hi,
Hi,
sir.
sir. Hi guys!
Hi,
Hi sir!
I am Maria Carmela Guangco.
And I am Juby Pimilgo.
And I am Crystal Bungay. I am Blasel May Rizan.
And I am Jim Paul C. Paduga.
So we are the group 4 and we are going to vlog our topic which is about intellectual property. Intellectual property or IP rights are invariably at the heart of franchise agreement. It is often the ability through the ownership of IP rights to prevent unauthorized third parties from reproducing aspects of franchise business model that enables the franchisor to demand a royalty payment from prospective franchises. These RIP or related rights include trademarks, patents, utility model, industrial design, and copyright.
Hello guys, I am here to share to you about the trademarks. Trademarks is the one of the most valuable assets of a franchise business is often the goodwill associated with the brand name. Trademark registrations represent the embodiment of this goodwill in tangible asset that provides a monopoly right to use a name in relation to the goods and services covered by the registration. This corners the right to prevent the unauthorized use of the name or a confusingly similar name by a potential competitor. In addition to the brand name and logo traditionally associated with a business, there are many other aspects of a company's trade dress or get up that may be protected through trademark registration. The definition of a trademark in many countries has been extended to include other potentially distinctive elements of a brand such as colors, shapes, sounds, animated marks, and even smells, taste, and touch. Recently, the actual get-up of a retail outlet has been the subject of a successful trademark applications. It is important to remember that registered trademark rights are territorial and registration in one country will give no rights to the use of that name or get up in another country. Indeed, the mere fact of having secured a registered trademark in one country will be no guarantee that the same mark will be available for use or registration in any other country. Therefore, where international expansion is anticipated, it is essential to conduct initial clearance searches to identify any potential infringement risk and, if available, apply for the appropriate trademark registration to cover that territory. This is dealt with in more detail below. A potential franchise considering entering into an agreement to be a user of the brand name in a specific country is likely to require confirmation that appropriate searches have been conducted and registration applied for. Suitable warranties and indemnities to this effect will be requested from the franchisor.
Patents. A patent, like a registered trademark, is a territorially limited monopoly right which enables its proprietor to prevent third parties from exploiting the invention claimed. In the patent specification, patent protection can be sought for products and processes that are both novel and inventive over the state of the art as the priority or filing date of the application for the patent. To be patentable, the invention claimed in the patent specification must not have been disclosed publicly before the priority or filing date of the application and must also not be of use over the state of the art at the date. To be patentable, the claimed invention must also meet a number of other criteria. In particular, it should be borne in mind that there are certain things that are exempt from patent protection in various jurisdictions. For example, computer programs, methods of doing business, and mathematical methods. However, these inclusions vary from country to country, and so, for example, an invention that might fall foul of the computer program or method of doing business exceptions in the United Kingdom might nevertheless be patentable in the United States, albeit that the scope for obtaining such patents in the United States has narrowed over the course of the past few years.
So hello guys, I will share to you the utility model. Utility model's inventions is an exclusive right granted, but it does not require the condition of the involvement of an inventive step to be protected. Any technical solution of a problem is any field of human activity, which is new and industrial applicable shall be registrable. In the other term, type of intellectual property right that protects inventions with a short term and the lower requirements for the novelty and inventiveness than patients. It is used to protect minor improvements or innovations to existing products or processes. For example, guys, the modified handle for a screwdriver, making it more ergonomic and easier to grip. This modification might not be novel and inventive enough to meet the higher standard of potentiality, but could still be protected with a model and utility model.
Industrial design is a tragic problem-solving process that drives innovation, building business success, and leads to a better quality of a life through innovative products, systems, services, and experience. Industrial design bridges the gap between what is and what's possible. It is a transdisciplinary procession that harnesses creativity to solve problems and co-create solutions with the Internet of making a product, system, services, experience, or a business better. At its heart, industrial design provides a more optimistic way of looking at the future by reframing problems as opportunities. It links innovations, technologies, research, business, and customers to provide new value and competitive advantage across economic, social, and environment spheres. Example of industrial designs. One is the Mini. Mini is a design classic that came about because of restriction in fuel supply during in 1950s caused by the Suez Crisis. The second one is the Coca-Cola Contour bottle. And the third one was the classic Vespa scooter. And many more.
Copyright. Copyright law is not directly related to franchising. Copyright law provides legal protection for original works of authorship, such as books, music, movies, and software. It grants the creator of such works exclusive rights to use, distribute, and display their creations and prevent others from using them without permission. In the context of franchising, intellectual property is often an important consideration. This may include trademarks, trade secrets, and proprietary business methods rather than copyright specifically. Franchisors often have valuable intellectual property that they license to franchises as part of the franchise agreement in order to maintain consistency and quality across all franchise locations. In summary, while copyright law may not be directly relevant to franchising, intellectual property rights are an important consideration in the franchising context. Franchises would carefully review the terms of any licensing agreements, including restrictions on the use of intellectual property and obligations to protect confidential information.